Thanks everybody for joining us bright and early for this exciting discussion. The topic today is the Supreme Court's recent decision in the Amgen v. Sanofi case and what it means in particular for the future of functional patent claiming. So as Joshua said, I'm Mel Bostwick. I'm a partner in the Supreme Court and Appellate Group at Orrick, focusing on patent appeals, and I'll be moderating the esteemed panel here. I'll ask each of our panelists to give a brief introduction of themselves.
I'm Justin Hasford. I'm a partner at Finnegan in D.C. My practice focuses on a lot of Hatch-Waxman litigation for branded side drug companies. I also do innovator disputes in the biotech area. Background is chemistry and molecular biology. I do district court, appellate, and also PTAB level work, and then client counseling.
And I'm Michael Penn. I lead the IP team at BlueRock Therapeutics. We're a wholly owned subsidiary of Bayer, and I also did work at Amgen for quite a while. And really just grateful to be here. Should be a fun and interesting panel. Thanks for having all of us.
Josh Sarnoff. I teach at DePaul University in Chicago, but I'm a local. And nice to see people up before 10 o'clock. And delighted to be with my co-panelists, who are a terrific group of people.
Hi, everybody. I'm Saurabh Vishnubhakat. I'm a professor at Cardozo Law School. I teach patent law, administrative law, civil procedure, and a variety of other IP courses. My background is in biochemistry, and my sort of legal academic background focuses primarily on the administrative process of the patent system. So I began my career in the USPTO in the Chief Economist's office, and a lot of my work has been empirical, so I will try and bring some of that to this discussion as well. Thanks for having me.
Excellent. Thanks, everyone. So we're hoping this will be kind of a free-flowing discussion this morning, but we wanted to start with some background on the Amgen case and what was at issue there, given some of you may not be as familiar with it as others. So the heart of the dispute here is about the meaning of the enablement doctrine, which is codified in Section 112A. And you can get the language on the screen here, but it's the requirement that a patent specification has to disclose, among other things, the manner and process of making and using the invention in sufficiently full, clear, concise, and exact terms to enable someone skilled in that art to make and use the invention. And so the question is essentially, how do you figure out if a patent claim has complied with that requirement? The enablement doctrine, it's been in the patent statutes going all the way back to the very first one. And this, the language here is the modern version that has remained essentially the same since the 1952 Patent Act. But the Supreme Court had not actually engaged with this statute the entire time that it's been in the Patent Act. So this was the first opportunity, was this the Amgen v. Sanofi case. And so the patents at issue here covered antibodies that were engineered to reduce levels of LDL cholesterol, which is the bad cholesterol, by inhibiting PCSK9, which is a protein that will bind to and degrade the LDL receptors that extract the cholesterol from the bloodstream. So I will happily give a brief explanation of antibodies unless one of my more educated panelists wants to do so.
I'll jump in.
Go for it.
So the antibody structure, if you look at the slide there, you can see it's a protein. It's fundamentally comprising 4 different subunits. So you see there's 2 long chains, and then you see the 2 shorter chains, and they typically are mirror images of each other. They're identical. When you look at how an antibody actually functions, the antibody binds to its target, what's called the antigen. right? So think about you get sick with a virus, you get the flu. The flu expresses these antigens. These are proteins on the surface of the flu, for example. The antibody that is specific for that antigen binds to it, sort of gloms it up, neutralizes it, and then your body gets rid of it. And that's one part of how your body fights off. Viruses, for example, can also work with bacteria, other just intrusions in your body. How do you get so many sort of unique antibodies? Well, that's in some ways just the magic of your immune system, right? You have millions of possible combinations. When you look at that structure, it's only those ends of the antibody that typically change. Right? And they're called CDRs. You might see that if you read the Amgen case. You'll hear talk about what a CDR is. So it's the CDRs. It's just those little protein changes, little amino acid changes that completely dictate all the different millions of targets that these antibodies can bind to. And that, in a lot of ways, is the heart of the case here. It's the heart of a lot of cases out there in the biotech field in general. And open to any questions on it throughout.
Yeah, good point.
One of the things for those of you all who have some background in drug development or are interested in the field, proteins such as this one, because of their structure that Mike was discussing and the nature of the molecule, it's just inherently more complex than a small molecule. If you think of, you get a headache, you take aspirin. Well, aspirin was innovated way back over 100 years ago, and all it is acetylsalicylic acid. It's a benzene ring with a couple of functional groups off of it. It's a very small, relatively straightforward chemical compound. These are anything but relatively straightforward chemical compounds. They have 4 levels of structure: a primary structure of amino acids linked together, a secondary structure that includes these disulfide bridges, and then you start linking them together, and you've just got this level of complexity that, with development in the biotech field, makes it fundamentally more complex than developing a small molecule. And small molecule development is very complex too.
So how do companies go about developing new antibody-based treatments?
So I will say, as complex as it is, and it still is largely complex, especially when you're going after new targets, antibodies are a well-accepted platform at this point. And they have been for 2 decades at least. A lot of drugs on the market using it. Established ways to screen for them. You can screen for them the really old school way is you inject a mouse or a rabbit with your target antigen. That animal then, their immune system develops antibodies. You can then pull the cells that make those antibodies. You can fuse them to create your own cell lines now that are spitting out those antibodies. The next evolution of injecting animals was actually to create human immune systems in the animals, and that was the case in the Amgen antibody platform, as well as the Sanofi platform, which was they're both engineered mice that have human immune systems. So they're putting out human antibodies, but from a mouse model. It's clever science, but again, it's been around for over 2 decades. You can screen, so you can imagine you get thousands, tens of thousands, millions of antibodies to screen. Sounds like a lot of work and effort. You can screen trillions of antibodies in, I think these days, probably weeks at the most. There's high throughput screens, high throughput assays that can very quickly select your lead antibody binders. And that, fundamentally, I think that point could have been made a bit better during the court hearing, because it sure seemed like antibody technology had not progressed in 30 years, and that is not the case at all. Screening is, once you know what to target and what to screen for, it is routine. It's as routine as it gets, it sure seems.
So like Michael said, both Amgen and Sanofi had developed these PCSK9 inhibiting drugs that were based on antibody technology. Each company had obtained patent protection on the specific antibody used in their drug. And then the issue arose because Amgen also obtained patent protection on the entire genus of antibodies, so the whole category of antibodies that perform a specific function. And you can see here, this is one of the claims in their patent, and it defines the invention as an isolated monoclonal antibody that does two things. When it binds to PCSK9, this target antigen, it's binding to at least one of these specified residues, and it blocks binding of PCSK9 to LDLR. So a lot of patent claims, right, are defined by what the invention is, kind of what it's made up of. This kind of claim is defining the invention primarily by what it's doing. And so we call these functional genus claims. And so the question that was teed up to the Supreme Court in this case, this is from Amgen's cert petition, and the way that they phrased it was based on the idea that what the Federal Circuit had done was changed the statutory test for enablement and imposed a different standard. And so they asked the Supreme Court to weigh in on, do you just look at the words of the statute, the specification has to teach you to make and use the claimed invention, or do you have to enable people skilled in the art to reach the full scope of the claimed embodiments without undue experimentation? And initially the case it was kind of teed up as a debate about that full scope requirement. Just, do you have to reach the full scope of everything you're claiming at all? As it evolved, it really became more about what does that mean? And you can see the sort of beginnings of that in the end of their question presented, right? Amgen's position was that the Federal Circuit had required you to enable a person skilled in the art to cumulatively identify and make all or nearly all embodiments of the invention without substantial time and effort. That was their characterization. Sanofi had a competing characterization. And so the fight before the Supreme Court really focused on just what does it mean to enable a person of ordinary skill to practice the invention across its full scope. And I think, Josh, you want to talk us through what the Supreme Court did?
Yeah, so it helps to break that down into three different ways of thinking about it. So remember, the statute says make and use the invention. So is the invention for purposes of making and using every embodiment that has to be made? So you have to make cumulatively all of the embodiments without without some level of effort? Or do you only have to make one specific embodiment within the scope of the claim? Or do you have to make each specific embodiment within the claim? Those are three different ranges. Obviously, one specific is easy. Cumulatively, all is really hard. And each specific is potentially pretty hard. So very different range of effort involved. And what the court held isn't clear, of course. And this is a problem with pretty much every Supreme Court patent decision we get. They don't have theory. They give us general statements. They rely on past precedents without actually applying them or making anything, that would help mere mortals in the patent system actually practice clearly and be able to give good advice. So what do they say? If a patent claims an entire class, a genus of processes, machine manufactures, or composition of the patent specification must enable the person skilled in the art to make and use the entire class. In other words, the specification must enable the full scope of the invention as defined by its claims. The more one claims, the more one must enable. So now we know that you have to enable the full scope of the invention. So we can at least rule out that you only have to enable making and using without too much effort one single embodiment within the claim. Okay, next slide. But if the patent claims an entire class of process, machines, manufacturers, or components, the patent specimen must enable a person skilled in the art to make and use the entire class. In other words, that's the last one. Next one.
Yeah,
Here we
sorry.
go. No worries. That's not to say the specification always must describe with particularity how to make and use every single embodiment within a claim class. For instance, it may suffice to give an example or a few examples. The specification also discloses some general quality running through the class that gives it particular fitness for the particular purpose, quoting a particular case. In some cases, disclosing the general quality may reliably enable the person skilled in the art to make and use all of what is claimed, not merely a subset. While we agree with Amgen that enablement is not measured against the cumulative time and effort it takes to make every embodiment within a claim, we're not so sure the Federal Circuit thought otherwise. Okay, we now can rule out cumulativeness. So now we're left with, do you have to actually be able to make and use without some unspecified degree of effort every single embodiment? We know you don't have to describe every single embodiment, but do you have to enable the making and using of every single embodiment? Well, the answer is, if it's the full scope, I think the answer is yes, you have to enable it, every single embodiment, but you don't have to describe all of them. And the language that makes that at least reasonably clear is make and use all of what is claimed, not merely a subset. So now we know you don't have to describe it all, but you have to enable each and every embodiment of the claim. So what's allowed? Nor is a specification necessarily inadequate just because it leaves the skilled artisan to engage in some measure of adaptation or testing. Decisions such as Wood v. Underhill and Mineral Substance establish that a specification may call for a reasonable amount of experimentation to make and use a patented invention. What's reasonable in any case will depend on the nature of the invention and the underlying art. Incredibly helpful. We now have a reasonableness test with no theory of how much time and effort is required. So all we know is that we used to say undue experimentation under WANs. We now have a different standard called reasonable experimentation. We don't know if they're the same or different. We also know that you don't have to describe every single embodiment, but you have to enable each single embodiment of the claim without unreasonable amount of experimentation, and now go out and practice. Okay? I see lots of practitioners in the room. What would make something reasonable as opposed to unreasonable amount of experimentation? Anyone?
The ones?
Say again? Of course it does. The more unpredictable, the more effort. That doesn't tell me what's reasonable. What's going to make it reasonable?
You make the argument that in this art, this is going to be reasonable.
Yeah, but why would a certain amount be reasonable and not? And there's no theory here. Absolutely none. So what do you do when there's no theory? Anybody? Most of you have been to law school. Yes?
Practice. You need to have that experience and practice.
What kind of practice is relevant here? The practice of being a lawyer. Analogical reasoning to the facts of other cases, people. That's what we've done. Okay. That's the holding. We have now a very easy case. When you have millions of possibilities and it takes trial and error testing, that's going to be unreasonable amount of experimentation. One data point from the Supreme Court. We have a whole bunch of other cases decided under other standards. We don't know if it's the same standard or not. What do we do with all those cases for analogical reasoning? Who knows? Make the argument.
So what does the panel think?
I think we've got a question.
Oh, yes.
Yes.
Yeah, I have actually made antibodies.
Fine. Good for you.
Made monoclonal antibodies.
Yeah.
And there's no way you can predict or identify that terminology. It doesn't make any sense.
So I was just told that if I have enough mice and enough time, I'm going to generate millions of different antibodies, some of which I can then screen without too much effort. But I have to have lots of mice, okay? Now the question, is that unreasonable or reasonable?
You can stumble on the right combination by accident.
Reasonable or unreasonable?
Who knows?
The courts, because they're applying it.
So what do we think? What do we think is
And it's not just
reasonable?
mice.
So,
Yeah. I can do conservative substitutions too. but
And the
that's-
technology's gone, you can use library screens, page display, yeast display, then you can screen, again, trillions of these possible combinations in days.
Do you
So,
see space for that to be deemed reasonable in the wake
Yes.
of Amgen?
Yes, I would say that is perfectly reasonable, and in fact, it's expected as part of the antibody screening process these days.
Except that was the state of the art for Amgen itself, and the court says that's not reasonable. Okay?
Unfortunately, that's where they shook out.
But that's how lawyers do it, right? This is the law, this is the case, let's analogize. What's changed since then? Nothing. Sorry.
okay. So I think there are two guideposts we can use to build on what Josh has quite correctly summed up about the holdings. One is that obviousness and enablement, as patent lawyers know, are in a pretty sort of clear symmetry with each other when it comes to what kind of inventive leap you have to make from the state of the art as it existed at the time of the, whether you're talking about the time of invention, whether you're talking about at the time of constructive reduction to practice, the leap that the person of ordinary skill would have been able to make versus what the inventor made, right, tells you that, look, if high throughput screening and or in silico assays, whatever sort of approach you have that is de rigueur for that field, is what's expected. And having done so, it is nevertheless an inventive leap. It is a non-obvious advance over the prior art. Then, okay, you've cleared the 103 bar. The same gap has to be bridged by everybody else upon reading your description, right, your written description. So it's frequently the case, as, again, many patent lawyers know, to say, well, look, if it was so easy to read your specification and your written description and get from the prior art to your invention, if it really is so straightforward, then how are you, the patent owner, also making the argument that this was non-obvious in the first place? And that's a frequent sort of tension that the patent owner has to contend with in infringement litigation. And the answer, of course, is, well, look, it was non-obvious at the time, and then what I did was, after bridging that gap, I built a rope ladder for you all to climb across with me, and that's my spec, and that's what makes this well-enabled and well-described. Okay. With that, the question of how we used to define reasonableness prior to Amgen was the Wands factors. It's been around for a long time. That framework is familiar. And so if you go to the next slide, please, Mel, right, what happened to Wands is unreasonable experimentation, the same thing as undue experimentation. We have one data point on this as well, and it may be enough. Federal Circuit seems to think in Baxalta, which was also an antibody genus claim case, in which, by the way, the patent owner lost. The facts of Amgen were materially indistinguishable in the view of the court from the facts of Baxalta, and they said in a footnote that both parties agreed that the Supreme Court did not disturb the Wands factors, and the court agrees. We see no meaningful difference between undue experimentation under Wands and unreasonable experimentation under Amgen. I don't think that that's dicta. I think that's central to the holding that that Baxalta, which was the patent owner, failed to enable. And the standard had to have been the same in order for that holding to stick. So I think, the state of what counts as reasonable or unreasonable is not that much different than what we used to have. It's more than one data point. It's all the data points we had under Wands. Those remain good law still. So I think that's, cause for more optimism than Josh and his countless mice might give us reason.
The only thing I'll add to that, Saurabh, is that, remember, the one's factors are just evidentiary considerations. They're not actually a standard. So I think that's right. I mean, it's hard to mentally parse what would be the difference between undue and unreasonable. And that's all the court has said. And similarly, all the court has said is, in this case, that it's factually indistinguishable from Amgen. But these are truly easy cases with, again, millions of potential things to generate to make the full scope, and with, even if it's easy to generate lots of them, making all of them might take a time. Again, not cumulative, but everything within the scope of the claim. So, easy cases make no law. And, we're back to when we get hard cases, we'll just apply the Wands factors to try to figure things out. But the standard probably hasn't changed. So then the question is, what was all the big deal about anyway?
Well, okay, so,
And I think if you look at the Bexalta case, you look at how the claims were drafted there, how they were written. It's an isolated antibody that binds factor IX to increase factor IXA production. And the case started out in Delaware. Judge Dyke sat as a district judge in that case, and then it got appealed up to the federal circuit. I don't think this result should have surprised anyone.
Yeah, exactly.
that's right. It is worth pointing out, real quick, of the Wands factors, right, it's frequently the case that in a multi-factor test, particularly one that is, these are a few factors, other things may also end up mattering, right? That's an escape valve that frequently exists. The Wands factor dealing with the provision of illustrative examples, here's my prediction for the next 10 years of enablement litigation. That's going to be the Wands factor that matters a lot more than the others, certainly more than it used to, because cumulative enablement, full scope enablement is now the order of the day. So how many examples you provide, the nature of the example, whether it's sort of speaks to the property, the function at issue, that's a through line through all of the members of the genus, will end up making an outcome determinative difference much more than it used to. So I think that's one way in which the Wands factors have been, their valence has changed after Amgen.
I'll disagree after Michael.
I want to get thoughts on Wands, right? So everyone agrees Wands is still good law. Wands fundamentally was an antibody screening case from 1988. Same issues here, right? And they had 4 examples, 3 of which were on point. So how can we say Wands is still good law, and yet these new cases, 25, 30 years later, we're basically saying antibody technology has not only not progressed, it's regressed since Wands. That's, I think, what we're all struggling, at least, when I talk to colleagues who I don't work in the antibody space anymore, but who used to work in the antibody space, we're still struggling with how to make sense of that. How can we say screening hasn't progressed in over 25 years?
Michael, why are you expecting lawyers to be consistent?
It is wildly inconsistent, and that's why when I see it, in writing, we didn't disturb Wands factors.
I'm not sure I understand the critique, because Wands can be good law without the facts of Wands still being representative of the facts we should expect to see in modern cases. So are you saying that the result in Wands would have come out different, the factual result in Wands should have come out differently under Amgen, or that
Yes.
even?
Yes.
I see.
Absolutely.
Right.
I have no doubt
facts
if a
of-
Wands case came right now,
Got
it
it.
would get shut down immediately, just like Bexalta.
And again, I think this really has to do with the growth in the technology and the use of the full scope of antigens, not just as probes, but as therapeutics. And, different view of what the patent system should and shouldn't be doing. But again, don't expect consistency from lawyers. Going back to Saurabh's point, I remember the language that I quoted, that you don't have to describe every embodiment in order to fully enable even a broad claim. So, yeah, it helps to have more examples, but if you have millions of potential embodiments, going from 4 examples to 6, I think, isn't going to make a bit of difference. The real issue has always been the wants factor, the scope of the claim. And, of course, if you have, as the court says in other parts of its opinion, a structure-function relationship. If you have a structure-function relationship, then you, A, get the Nobel Prize, and B, you also can, describe adequately pretty much anything you want by giving a few examples. It's without that that we are in trouble and have no theory to say how much is enough to say you've characterized the claim. What I like to do, these are functional claims. I like to give the structural claim example from Graver Tank 1, which almost no one remembers, right? And you have, the court said that with just a few inoperative claimed embodiments, that it had claimed beyond the point of validity. A few inoperative embodiments. With a functional claim, you never have inoperative embodiments because by definition, the function makes sure that they're operable. But you have to test things you don't know and have no way of even guessing about in order to decide if they have the function. So, how many, when functionally claimed, things beyond those things that will actually work makes it unreasonable? That's the right question. Of course, we have no theory to get at it because we don't have any theory of reasonableness, just like we don't have any theory of what actually makes something obvious. How much time, effort, money is the relevant comparison? Wouldn't it be nice if for once the courts actually gave us some analysis of the real issues? I know, it's a vain hope. But it's not like they didn't get it, because there are these things called amicus briefs.
Is the structure-function relationship, are antibodies unique in the sense that that is so unpredictable in this area, or are there other technological areas where that's a problem as well?
Small molecules. If you, take a look at thalidomide. Okay, thalidomide, the active enantiomer treated morning sickness in women. The inactive enantiomer caused birth defects. The only difference between those two chemical compounds is right hand, left hand. Okay. There is zero chemical difference between those compounds except the extent and the direction to which they rotate plane polarized light. So anybody wants to say there's any predictability in the chemical arts, including small molecules, I'll give you that example.
You can do any technology. It's not just biochemistry, simple mechanical technology. I claim a machine that can move this cup from here to there, right? I've built this one machine. Now I claim any machine that can do it. And the only question is, I haven't described the structure-functional relationship between my machine and all of the others that can do it. Am I entitled to it? Right? You have the exact same question. This is just the core of patent law, and we have no theory. Right?
You'd almost look at, like a tire.
Yeah.
Look at your car tires with all the grooves and treads in it. What if you were the first person to come up with a grooved tire? Could you claim that without describing all the millions of different tread patterns right now?
I think the question would be, is there something common to all of them? Although as soon as I say that, then we start getting into written
So do you
description
get
too.
that groove?
But if not all grooves work, and you
Right.
don't know which ones do and don't, that's the point, right?
I think on written description, right, the reliance of the court on the incandescent lamp patent case, right, as an enablement case, I think is well-founded, but you could very easily recast incandescent lamp as a written description case. In fact, you could do that with any.
O'Reilly. Yeah, they're
Okay, well, we're not going to go down the O'Reilly rabbit hole until after we've had a few drinks.
It's a little early.
This is going
But
off
I'm
rails.
with you.
We're academics. No,
So the incandescent lamp case, this is, it was, well.
the filaments, yeah, the Thomas Edison, right, all the vegetable plant filaments and so forth. And the Sawyer and Mann patent basically claimed broadly, but then Edison did the actual work to say, okay, these ones work, these ones don't, these ones kind of do, and so forth. But any situation in which you describe a few and claim a bunch could be recast not only as an enablement case, but additionally or alternatively as a written description case as well. And when the court tells us you don't need to disclose everything in order to sort of satisfy full scope enablement, I think it does two things. One, it incentivizes parties to strategically choose, are we going to make this an enablement challenge versus a written description challenge, or defend accordingly? And alternatively, it reignites the debate that we thought we had settled in Ariad, which is whether the enablement and the written description requirements are really two different requirements, or are really just two sides of the same coin. And then we're back to parsing commas in section 112A. So I think that's the beginnings of a set of questions that could get us the theory. But there's a case that was included in the CLE materials, right, Orexo versus Sun Pharma, which also applied the Amgen decision and basically said, look, Amgen is about genus claims, and Orexo's patent here is not a genus claim at all. They conceived of the invention at a narrow enough level of specificity to say that this is just one thing, not a class of things. And you could do that with some caveats. You could do that with a lot of different inventions, right? The invention consists of this, parentheses, and all sort of minor structural variations. That's one invention, one embodiment, rather than a whole class. You could always take an embodiment and drill down and make it, okay, well, all these little obvious variations, which are also covered by the doctrine of equivalence, which we were talking about yesterday over dinner, right? This ends up being a class of a whole bunch of varieties rather than a single embodiment. So do you define a particular embodiment as a single embodiment, or do you define it as a set of embodiments and their minor variations? If, as the court said in Orexo, that's a point at which you can differentiate the case from Amgen and say, no, this is perfectly well enabled because the full scope is just the one embodiment. I think we're going to start to see fights over the level of generality at which claim construction is carried out as well, because that's a way to sidestep the very difficult question of what the full scope would even require.
Yeah, so the problem with that approach, of course, is that this was a functional claim because of our idiotic magic words approach.
Sure.
It should have been subject to 112F, in which case what you get is a claim that sounds exactly like you said, which is these, this structure that I've described and things that are functionally and structurally equivalent to them. And that's probably the right thing. The problem is we still don't have a theory about what is structurally equivalent to an antibody claim when we don't know the structure-function relationship. No. So, Michael, you're going to answer that question for us.
I wish I had the answer. Right? I think we'll see more. I imagine, Mel and I were talking earlier, this will be the next wave of litigations. Right now, I think as cases are heading into the courts, post-Amgen, you're starting to see people try and shoehorn in either 112F type of claims or a DOE type of strategy. Unfortunately, they're using specifications from 10 years ago, for example.
And
they weren't drafted with this in mind.
Just to step back a moment, just to make sure everyone is understanding what we're talking about, right? So with Saurabh, you mentioned this approach of, okay, just really claim one thing and then all the minor variations. And there's kind of two doctrines that are relevant there. One is the doctrine of equivalence. In other words, you can infringe a patent claim by doing not literally what's described in the claim, but some insubstantially different variation. And the other is claiming under the protection of Section 112F, where you can use functional language, but then your claim covers not everything that performs that function, but the particular examples you've given in the specification and equivalence thereof, as the statute says. And so I think the question is kind of, is that enough protection? Does that actually protect the first person who figures out the groove tires?
Yeah.
Yeah, well, and so if you have to go to doctrine of equivalence in this field, we do have good doctrine of equivalence case law for patent owners in the chem, pharma, biotech arts. You start with Posen v. Parr from the Fed Circuit in 2012. They use the function way result test, but there you had sumatriptan and naproxen that were together in this tablet that had different types of how the tablet was put together such that it controlled dissolution. And the generic company there, Parr, thought that they were going to be really clever and switched around how effectively how the active ingredients were put together and how the distribution of them was. And the court said, no, I mean, it's performing substantially the same function, and it gets in substantially the same way, and it gets the same result of modifying the dissolution profile here. And then fast forward 4 more years to Intendus v. Glenmark, and you had Glenmark trying to say, well, hey, we're using isopropyl myristate in our generic product, and that's not equivalent to these two, to lecithin and I forget what the other ingredient was in there. That's not equivalent to those two. And the court said, well, it sure is. It's, again, function way result. And then fast forward 3 more years, you had UCB and you had Lilly v. Hospira. Lilly v. Hospira. Pemetrexed said disodium. Pemetrexed said trimethamine. And the court said, look, you can look to insubstantial differences there. In the chemical arts, sometimes it can be insubstantially different. So you do have that guidance from the courts. And, maybe 112F, ex parte gleave, Fed Circuit said you can use that in this field. Maybe that's where things are headed.
It could be, right? And that will be the next wave of litigation.
Mm-hmm.
And right now, though, we're still struggling with, is that a viable strategy in the antibody space? If it is, where do you look for what are equivalents of an antibody? Is it the core antibody structure? And then these equivalents are those differences in the amino acids at the CDR level? Tough to say.
Yeah.
I don't think we have clear guidance on
Isn't
it right
the
now.
right answer from your perspective that the way is something called ionic bonding and they all do it? Right?
They do and don't.
Yes
so
and
it's
no.
not that.
Well,
that's the
ionic
problem,
and covalent.
Covalent,
Yeah, I know.
exactly.
Right.
And there's-
right. But this is the same way, right?
In
And
essence,
the question is
yeah.
how much of each. And, that's maybe how it's going to split, is if it's enough of the same kind of ionic and covalent bonding, then you're in. And if it's a little too much different, then you're out.
It could be. I mean, big picture, the function you're looking for, so in the Amgen case, was blocking.
Right. No, but
That
it's really the
receptor
way
interaction.
that distinguishes, I think, the antibody structures that bind from those that don't, right? Or those that are, you've identified from the other ones that will do it too.
Yeah, it's
the
a
way.
complex interaction between the amino acid structure of the epitope, the
Right.
target,
Yeah.
and the amino acid structure now of your CDRs.
Right,
and how
which
they
is
interlock. in
Right,
essence.
covalent and ionic bonding, and the question is is it
There's some
similar
hydrogen
enough?
bonding. There's
Okay.
it's a little more complex. Sometimes there's exclusion. It's
Well,
more complex than that, but
And right, we see here one of the big differences between the biotech field and the small molecule field in Hatch-Waxman, right? Because at the end of the day, if you're a patent owner, what are you trying to do? You're trying to exclude competitors from getting into the marketplace and competing with you economically. And so if you're a patent owner in the small molecule field under Hatch-Waxman, you innovate a new chemical compound and you use it as your active pharmaceutical ingredient. If a generic drug company wants to come in and compete with you, they have to file an ANDA, an abbreviated new drug application, that has the exact same active pharmaceutical ingredient. So the simple case, aspirin, if a generic drug company wanted to come out and file an ANDA directed to generic acetylsalicylic acid, they can't go use a different chemical compound. But here, competitors in the biotech field can change the chemical compound. They can use a different protein with a different sequence of amino acids. If it, they obviously need to bind to have the functionality, but therein lies the issue with, at this point, with patent owners engaging in functional claiming.
I think we had an audience question.
Yeah, so does it matter to you whether we view the invention here as a particular amino acid sequence, as a particular structure, or whether we view the invention here, and course, now we're starting to get into, like, what is the invention, right? What's the point of novelty, all those types of things. But do we view the invention as actually identifying which residues on the protein, the PC, whatever protein, that if you block those residues, right, with an antibody, it will disable the protein, right? And it seems to me like it's the latter, right? That the invention is identifying which residues, generating a whole series of antibodies that can bind to those residues is simple based on the prior art, and therefore it should be enabled if that's how we view the invention.
That is. So the invention, to be clear, isn't the residues. That would raise 101 issues. But you're right. The invention fundamentally in the antibody space is all of that hard work is figuring out what to target.
That's the part that's not obvious.
It's not, and that's what makes it not obvious. Once you know that, right, and that's what's taught, that's what is brought to the public, that's the quid pro quo. Once you know that, it's, in theory, trivial now to run your screens, your high throughput screens, because you can screen 1 trillion variants in a week, for example. You will get, at that point, antibodies that meet the claim limitation.
So this is why it's important to have gone through the full scope of the 3 different characters. You're absolutely right. You are going to get not only the ones you had already discovered in the throughput screening, but many others. But remember that the claim covers every potential embodiment that has the function. You have no way of knowing if in your screen you have everything in the claim. Therefore, how many millions of mice do you have to run until you are 99.99% confident you have screened all of them?
But that's kind of a, going back again to this analogy, that's just a question of likelihood of succeeding, right?
Yeah.
You know you're going to succeed. It's going to take about a fair amount of work.
You know you succeed in getting some. You don't know you will ever succeed in getting all. That's the problem. So that's why without a structure-function relationship, you can't limit the claim structurally to only those things that work with not too many inoperative embodiments, right?
But then what happens to claim scope generally, even outside of the biotech space, right? At that point, you have to, so this is the right answer in my mind, is you have to actually disclose a structure-function relationship to claim functionally a genus. But that just means the scientists have to actually do more work before you claim broadly by genus. That's all, right? Do more work, get your Nobel Prize, then claim.
So Michael, how
I
do
see
you?
Hans out there shaking his head. Hans, do you have questions?
To follow up though on the point of, when we're talking enablement, it's really couched as, like Emily said, it's a question of do you disclose enough to give people a good likelihood of success in also replicating the invention, right? As a commercial competitor or anyone, my goal is not to make every embodiment. I don't want to make like 100 million different antibodies. I want to make one that works. And if I can do so in reliance on your specification, I would imagine, like most normal people say, well, that seems enabled, but we have 50 different people to try. If they can also make antibodies like that, and they all succeeded, right? And we have a litigation where there's no evidence of people who said, oh, I tried and I couldn't succeed. Well, that tends to be another thing that we sometimes see in these cases. The arguments are made, broadly, nobody could make them all. But in the case, there's no evidence of somebody who tried and didn't succeed. Nonetheless, we try and shoehorn this into an enablement argument.
I agree. Enablement is a silly doctrine to address this, but leaving that aside, Hans, that argument, that precise argument was made by Jeff Lampkin during the Supreme Court, and the Supreme Court paid no attention to it. The argument was we should only care about those embodiments of the claim that a skilled practitioner would be concerned with. And a skilled practitioner, in your case, is the competitor. The competitor doesn't care so long as he gets one embodiment that isn't the specifically identified species.
Without undue experimentation.
Right, but that's not the test. That's all I can say is that's not the test that the Supreme Court established. Right?
So what was it trying to do?
The Supreme Court? I haven't any idea.
You probably got some good guesses,
Why are you
right?
asking me, Hans? What's your guess as to what was going through their minds? Like baseball, the opera?
Pretty much.
Okay.
Things that were said in oral argument, hey, your honors, this is an effort to make an end run around section 101.
Right.
Like all sorts of things that I think got muddled in the jurists' minds. I'm like, yeah, let's decide this case.
It sounds like you need a specialized patent court to decide these issues.
From your lips to God's ears, but, you know.
May I address that? So in the time since this decision has come down, there have been about 12 PTAB decisions on the PGR side, a non-trivial number on the IPR side, which is weird because IPRs don't address 1 and 112 issues. But at the petition stage anyway, right, you'll frequently see 112 type arguments saying this is not susceptible to claim construction and therefore should be set aside. But the PGR decisions, both from the patent owner side and from the petitioner side, are making these very arguments on the basis of Amgen. And so to the extent that the PTAB generates case law in a relatively formal, adjudicatory setting, this might be the basis for without presuming to speak for the Federal Circuit's views on Chevron deference, might be a place where the patent office says, look, here's what we think tech by tech, sector by sector, Amgen really requires, whether it's how to pitch at the right level of generality for whether it's a genus claim or a single embodiment or a handful of embodiments, whether this is unreasonable experimentation or reasonable experimentation. Those are all questions the Patent Office could answer and then, would have to sort of be, muscular enough in its request for Chevron deference to say, look, our analysis of the law and our command of the science and the technology underlying the dispute here warrants some degree of just deference from the courts. I think that's not an unreasonable thing to expect going forward.
But they're stuck with the Amgen decision and what Amgen provided, and they're stuck with now Baxalta and what was provided. So they're, in some ways, they're so incredibly constrained. They no longer have that flexibility. Again, it goes back to, look at Wands. Look at what Wands provided back in 1988. And now what's required. More is, even though the technology has progressed, radically since Wands.
So why do we think Wands came out the way it did?
Back then, I think because it was a reasonable decision. They looked at what the skill in the art was. They set forth all the factors. And everybody agreed that, yeah, this is not unreasonable. It's not undue experimentation. And that was my point earlier. When you look at now what is required, it's not even taking us back to Wands. It's taking us before Wands. It's saying there's no high throughput screening. Right? They made hay of that. Oh, you have to screen millions and millions and millions. And you see that also in the written description cases. Making it seem like, oh, it's going to take labs hundreds of years to do this. That's BS. It takes labs a couple days to do it.
So do you think that absent a structure-function relationship that's disclosed, we're just not going to be able to?
I don't think you can do it.
Yeah.
And then, strategically, again, from the corporate side, what do you do?
Yeah.
You have no certainty. There's no way to predict where these cases are going to go.
I think we had a question.
Just a comment about the PTAB. I remember only one decision since the inception of the Act. The board decided not to follow the CIP2. Only one. So I think the comment that the PTAB is going to partially assert the higher court said
I think you see where, in the cases where the PTAB gets affirmed at the federal circuit, if you look at the statistics, affirmance out of, I think, IPRs, PGRs, CBM, the whole gamut, I think is around 73%. I think the straight reversal is only like 5%. And then there's, vacate and remand that happens in maybe 20 or so % of the time. Well, yeah, so my point is, to the extent there might be an opportunity here for the PTAB, it might be to try to cast it as more of a factual determination that they're making, because that's going to be a just inherently under the standard review, it's going to be more difficult for the federal circuit to reverse the PTAB, and if they can cast it more as a factual determination. But yeah, I mean, the PTAB isn't going to go in there and say, we're not applying Amgen v. Sanofi, we're not bound by that law. Well, you kind of are. It's a Supreme Court precedent, right?
So go ahead.
One sec. So here's, I think you're right for a different reason. The PGR, when I was talking about PGR, is primarily obviously going to be in the context of patents that have just issued, and the technology hasn't really progressed far beyond where it was at the time the patent was being prosecuted. Obviously, it'll be a year or two, maybe 3, but it won't be 10 years out, 20 years out, just by the nature of when PGR is available. Most of these cases, I think the work that Amgen is going to do of the sort that creates the problems that we're worried about is when the technology has progressed so far beyond what the throughput screening efficiency was, or the predictability, the ability to predict function based on structure, is where you've got a patent that's 10 years in, 15 years into its term, and it's being litigated, which is where most patents that end up being litigated get litigated, is 10 or 15 years out. At that point, you're going to try and retrospectively ask, well, where was the tech at the time of constructive reduction to practice, right? And in that situation, PGR is not going to be available. So the PTAB is not going to be able to do the interpreting of either Section 112 as an initial statutory construction matter or an analysis of the case law and be entitled to deference because they don't have the statutory authority in IPR to do this. And that's where Amgen does most of its work, because Josh's problem, I don't think, is as salient where you're only 2 or 3 years out. It's all of the unanticipated after arising things that are covered by the claim but couldn't have been foreseen by the person of ordinary skill or even the innovator themselves. It's going to be all the unanticipated after arising embodiments that are covered by the text of the claim or by the doctrine of equivalence, but couldn't possibly have been foreseen. And the question is that fight best had at the level of claim construction? Is enablement the right place to do it? I tend to agree with Josh, it's not. Or it might be a written description problem. And the written description problem might be, the safety valve here.
So here's some good news for prosecutors, right? All claims are genus claims. Let's start with that. You have a term like, a computer with a elbow that does something. You have to interpret elbow, or chair with a leg. How many different things qualify as a leg? It's a genus of leg. When you fix the structure through claim construction, then you know what it is that is the range of structures that you then have to test. So there's a limit. In contrast, when you claim functionally, you have no idea how many things you have to test and whether you've gotten them all when you have tested. So what's everybody going to do? Leaving aside the concern about prosecution history estoppel, they'll make their broad genus claim anyway, which they shouldn't because of prosecution history estoppel, but they'll start claiming subgenuses by structure. Lots of them. Which means what? More filings, more work for prosecutors. This is great, right?
It's actually both. I think you're seeing both strategies employed.
Right.
You can do let's have a computer spit out every possible CDR sequence.
Right.
Or it's the opposite, and it's actually antithetical to our patent system. Disclose less. If I know in the U.S., I'm not going to get a broad antibody claim, why do I have to teach anything related? If I find a new target, but I know I'm not going to get those broad claims, why do I even have to teach the public what that critical new target is? It could be the cure for cancer. And I'm going to say, you know what? I'm going to file on my antibody sequence. I'm not going to tell anybody what it's binding to because I don't think I have to.
Right.
I've got a defined structure that I will, it's got function, I maybe have data, but I'm not going to teach the public what it's binding.
Yeah.
Is that serving the best interest in the constitutional mandate of our
Even better,
patent
just
system?
keep it as a trade secret. You know, they can reverse engineer the antibody, but sure, right?
Way down the road, right? So eventually they could take, once they realize, oh, there's that patent that covers their blockbuster drug, it's too late at that point.
Whatever-
You've lost a decade or two.
Whatever happened to the integrity of scientists to say, I just found something valuable, I'm going to tell everybody about it?
Well, that's what I struggle, that's what I
works in a
wrestle with.
university setting,
in
not so well in a
university
corporate
and
setting.
startups.
I understand.
That's what we struggle with all the
Yeah,
time.
no,
But
I get it. Right?
Mike, what you just described, claiming in that way, it's just, I mean, it is, you're going to have more opportunities for competitors to go in and design around those claims. It's just, it's not.
But they
gonna-
won't know.
Well,
There'd be no reason for
Conservative
them.
substitution is a really easy thing. Unconservative
I just won an IPR where the other side tried to argue that conservative substitution was a really easy thing. So it kind of depends.
So I think the question here is this good? Is this good for industry? Is this good for the public?
It depends who you ask, right? When you look at all of the support that was filed on both sides, it's so clear it was a split. I can tell you, and even within large companies, there were splits within the company.
So
As a small company, what do you get asked from investors? We were talking about this earlier. Investors ask, can you block the world? And also, do you have freedom to operate? So when you look at this decision, well, now you can say we've got freedom to operate pretty clearly for most cases, but we cannot come close to excluding competition anymore.
So one way of thinking about is this a good thing is the same question about the standard of obviousness. The higher the standard, the more people reach to actually develop the understanding of something that's more different, more valuable, newer, whatever. Similarly here, the more difficult you make to claim the genus, the more the scientists struggle to understand the structure and function and get that Nobel Prize. So I understand.
We don't have unlimited resources.
I hear you. I'm just saying those are the competing balances between small but protective steps versus big but hard to protect steps.
That's true.
Right.
But even universities don't have unlimited resources.
Oh,
so-
come on. Think of all the wasted money in the world and redirect it, right?
Yeah.
How about progressive taxation and government subsidies? I mean, really, there's a lot of money out there we're not using properly.
And with that, we might be wrapped up at this point.
Welcome questions.
Let me give you the mic real quick. We are recording and no one can hear you, so. And if anyone else has a question, please raise your hand and I'll come find you.
So there's just a policy question regarding the small versus big dichotomy. So in terms of small biotech startups, those with, they've got some substantial amounts of capital because people are interested, but they don't have a product, they're not in the market yet, and their end goal is to, 3-5 years to be bought out and cash out. That's the typical scenario, right? In that scenario, and if it's not, tell me, but if that's the scenario, what's the proper incentive for tweaking the existing rules for 112 to incentivize them? Do they want to have strong rights, or do they want to have freedom of operate with negligible rights, just protecting their individual embodiments, the single particular structures exactly as disclosed, or particular methods of making the structures exactly as they did them and showed that they work? What's better for promoting the small startups in the biotech space?
It depends on the startup.
Depends on the marketplace competitors out there.
I think when you're talking about biotech, the really high capital investment requirements at the outset do make the acquisition, right? You want, I think, on balance, stronger patent rights will be of greater interest than freedom to operate. But if you're talking about a high-tech startup, then the acquisition, right, the idea is, look, being first in the marketplace and having some trade secrecy and employee mobility, right? There are a lot of patent-adjacent incentives that will end up making more of a difference in that industry. And I don't know the extent to which Amgen is going to be interpreted by the Federal Circuit and maybe by some of the district courts where a lot of biotech litigation takes place, District of New Jersey, District of Delaware, as being primarily limited to the biotech sector. If it ends up being applied more broadly than that, then the question of incentives across lots of different industries will end up, coming to the fore. But I don't think we're there yet because it's mainly just been applied in the biotech space.
So I'm old enough to remember the Cohen-Walsh study where lead time advantage was what everybody really cared about, not patent rights. But, times change.
And I will say patent rights, so to your point, if you're a small company, a startup company looking to get acquired, or I'll say a university looking to generate revenue and license that. We see this all the time. You're doing a diligence on a university patent, say it's for an antibody. They may have discovered a new target. Nobody else knows it, but they provide a single mouse antibody as an example. You do the diligence, you say, even before Amgen, you'd say, they're not getting that claim. Why would we bother to take this license when everybody else in the world is going to have freedom to operate in the space? So why should we get encumbered by a university patent?
Michael, is that story the same regardless whether the university wants to non-exclusively license the patent as a revenue source versus spin off a startup and exclusively license it to the startup?
Very different, but you would never do a non-exclusive for a lead drug.
Yeah.
Unless you were forced into it. If they had the issued patent and you were actually worried about it and they'd already licensed it to others non-exclusively, then to avoid litigation, you might take it.
Or they took federal money where they're actually supposed to be non-exclusively licensing unless they really can't. But, nobody follows that.
I mean, it's the march-in question that I'm thinking of, right? So, like, we've never had a march-in, but we've had a bunch of petitions, and the political pressure for that post-COVID is, I think, mounting. Yeah. So the day may come soon, for better or worse, where that ends up being the NIH's hammer against the university to say, look, the startup model has had its day, and you can still do that sometimes, but it's really better, in our view, as the funding organization. I'm just curious whether you think that's an accurate characterization of the landscape.
No, I think we'll see probably less licensing at this point, at least for lead compounds such as an antibody. And it's unfortunate.
Yeah.
Just to make sure I got it straight, did you address the possibility that we're dealing with situations where there are blocking patents by the big companies? And the question then is whether the university researcher can form a small company or whether a small company can be formed around a new concept which would potentially be blocked. After all, they can't be bought out in that case by anybody that wants to have an exclusive right because the purchaser would be blocked by the other blocking patents, the genius patents in the area. So that's the real question I had. Maybe I didn't phrase it correctly. Given that fact pattern is your conclusion, what's your conclusion as to what's the best possible policy in this area for 112 issues? And I guess that's directed to you, Michael, since you raised the issue.
Yeah, I don't know if there's a best policy because, again, it's split. If you're a startup that has a single molecular entity that might fall under, say, a big company's broad patent, of course you want to clear the path. And I think you saw that in some of the amicus filings where small companies sided with Sanofi. They don't want broad claims, likely for that reason. On the other side, you had a lot of small companies who want that broad claim because they're doing, I'll say, bigger research, maybe true innovation on the bigger questions. And they want that broad patent because they know if they don't get it, a big company can throw a team of 200 researchers at the problem, and they will beat them to the market every time, and the small company won't have a chance. And investors know that, and because of that, the investors back out.
So Michael, cultural question. Are there any small companies that still would like to maintain their integrity, and when the big company with the blocking rights says, we'll just buy your company, they'll refuse? Or is it just a question of how much? Right?
That's shareholders. I mean, that's.
I mean, seriously, because that's how it gets.
Parachute, right?
Exactly. I mean, that's I thought what everybody wants is they want to get bought by the big company, right? Eventually, and
They don't
then
want
it gets.
it, but it's, you
Right.
frequently don't have a choice. It's shareholder value.
Yeah.
Once you make that decision to go public, it's, in a lot of cases, out of your hands.
Yeah, that's fair.
Got a question?
So this is going to some of that same question. Is there, you talk about the incentives on the part of the client, but is there a way to align incentives for the attorneys, the prosecuting attorneys, to try and shape the claim so that there is more consistency between the scope of what is disclosed and the scope of what is protected? It seems like, I remember for a long time from law school on up, they were saying, you want to get as broad claims as you can support. Now that I've been through the grinder several times, I don't want the broadest claims I can support. I want the broadest claims that I can defend, which is much, much narrower. I mean, is there a way to align the incentives that way?
Yes.
Using claim dependency, using continuing applications, et cetera. Yeah.
I would think going forward, you're also going to see, as I touched on earlier, a strategy of let's go into this brand new filing with a DOE strategy in mind, or a 112F strategy in mind. And it will be a completely different specification, right?
Yeah.
DOE raises a whole host of really messy issues,
Yeah.
right? Dedication to the public if you don't claim it. How do you square that, though, then with an international filing, right? And that's any company these days needs to take into account the whole rest of the world. It's a big market. So what do? Do you draft separate specifications, one for the U.S. now, because we're in a lot of ways out of touch with, say, the European patent system, although the European system is starting to squeeze in the same direction.
And we saw that in Eagle, the dedication disclosure issue. We saw that in Eagle v. Slayback. Eagle lost a Rule 12c judgment on the pleadings in front of Judge Connolly in the District of Delaware. And Judge Connolly, generally speaking, tends to be a fairly pro-patent judge. And that was affirmed at the Federal Circuit. And so could that have been prevented by better claiming? Perhaps. Claim the other embodiments that are disclosed in the specification, and then you don't have the disclosure dedication problem. Of course, it's how many claims do you do? I mean, it's sort of depends on the facts and circumstances.
So here's where we can rely on legal ethics, because to knowingly overclaim is a violation of your attorney obligations, and of course subjects your inventor to a false declaration with potential jail time. Of course, that's not going to happen, but what will happen is the lawyers might actually encourage the client to just wait a little bit longer, maybe a couple of extra weeks, run a whole bunch more tests to see what works, and then claim lots of subjudices that then you get equivalency protection beyond to try to get at the scope that they couldn't have gotten originally. And that's much more protectable and much more defensible and probably the right thing to do, and of course avoids being unethical and having your client lie under oath. Right?
Do we have another question?
Yeah, I have a practical question. How do you avoid summary judgment in all of this, if there is a way?
Create a genuine issue of material fact.
I meant in the other direction. Yeah, I mean, the disadvantage to all this is a trial lawyer's dream. all of
And
this
the
stuff.
prosecutor's dream. Yeah.
Well, it's more of a trial lawyer's dream when you get down to it, because once you get the case, that's nice, but you still got to monetize it. You still got to license it or apply it against someone. I would be thinking, I don't know whether post-grant works, keeps you away from a jury. If you go an ANDA route and you don't launch at risk, you don't get a jury.
Right.
But otherwise, I don't see how you're ever going to get summary judgment in this stuff, and you're dooming yourselves let me finish. You're dooming yourselves to a long, bloody campaign. And please don't tell me 112F. We just had a new case out of the Federal Circuit. What is it, Sisfeld? 2 weeks ago. The whole damn case is about 112F. I've been reading 112 cases for years. That's a blunt instrument that is not very definitive at all. It changes every 15 minutes. So I was just, seriously, I wasn't trying to bust chops. I was just wondering whether there was anything you guys had come up with that might get you to summary determination without having to face a jury.
So operators are standing by to take your contributions to the Supreme Court Building Society, but leaving that aside.
They don't take bald Italians, trust me.
Yeah. So remember that enablement is a question of law based on underlying facts. It should never go to a jury, but of course we do that. I mean, so many stupid things that we do, right? So yes, there are some facts that are going to be in dispute, such as how much effort, but most of the Wands facts are not, I think, going to actually be in that much dispute. It's really about where do we draw the legal line, and we have no friggin' idea. So that's where you as a lawyer can actually start articulating theories about the line drawing that would help these judges. So tell us, what makes something unreasonable versus reasonable, Ken?
Well, two points in response to what you just said. Remember, there are such things as advisory burdens.
Ken.
Yeah.
And while it's up to
While
it's up to a trial judge to decide whether he or she wants to use it, it can get,
Sure.
you can end up down that
advisory
down
verdict
that
from
road.
people with a 10th grade education determining Nobel laureate science. Exactly.
But shouldn't it be a question of fact?
No.
Why?
Okay.
Because any question of validity should be a question of law.
Enablement, where you're looking at what's reasonable and unreasonable?
Yes.
Well, that is the question the Supreme Court did not take, so maybe stay tuned for that one, but I think we are out of time. So thank you, everyone. That was great.